Thank you. I'd like to call upon Mr. Dugar, partner of MAH Management Consultants, to welcome the guests, please.
Good evening, ladies and gentlemen. Ramadan Mubarak, and a very warm welcome to this networking session and a technical session of MIRA. And very happy to say the third one. We started off with the Middle East Risk Management Conference in March early this year. We followed it up with an informal networking session at the Capital Club. And we are here now during the holy month of Ramadan. I'm also pleased to share with you that we are now almost 80 plus professionals on this forum, very actively sharing knowledge, experience, ideas and views. And a lot of former colleagues are also catching up with each other. A few days back, 3 or 4 members got added on a WhatsApp group, and it apparently turned out that some of them were ex-colleagues from Axis Bank, and there was a lot of excitement in catching up. Another interesting thing happened. I think Mr. Asim today walked into the room, and I was just standing beside him, and he mentioned to a colleague that they had been to hostel together, if I'm not mistaken. So let's keep this spirit moving. I think we are in the right direction, and in a positive direction. We'll plan our next event after the summer holidays, because a lot of people will be traveling over the next 2 months. So we'll hope to see you back in September, early September. Also at the last networking event, we briefly discussed upon this idea of having a technical session or a brief discussion kind of a thing on a pertinent topic which would be relevant to us as professionals. So here we are. This is the step in that direction, and we have Mr. D.K. Singh with us, who will talk briefly about the wealth registration, which is the latest trending topic in UAE right now, and the IFC courts as a jurisdiction. So once again, a warm welcome to all of you. Thanking you for making it today evening, and we look forward to hearing Mr. D.K. Singh soon. I'll request my colleague Divya to introduce Mr. Singh to us so that he can take it over from there. Thank you very much, ladies and gentlemen.
Mr. Singh is the managing partner of KBH Qanun in the UAE. He has extensive commercial and dispute resolution experience spanning over 18 years. He has the experience of representing clients in litigation in the 3 jurisdictions and in the international commercial arbitration, including mediation and commercial settlements. He has been involved in multi-million-dollar disputes and has advised on matters arising out of oil and gas contracts, electricity and construction, commodity trades, and shipping matters. His previous experience was with SNR Denton London for approximately 11 years, Hammond Suddards London for about 3. He's also worked with the Private Secretary to High Commissioner for India in London for 5 years, and as a junior counsel with the chambers of Dr. L.N. Singhvi at the Supreme Court of India. Ladies and gentlemen, please join me in welcoming Mr. D.K. to the MIRA Forum.
Hi, good evening, ladies and gentlemen. I recognize that I'm at the risk of being discredited by all the risk professionals in terms of what I'm going to speak. So take it with a pinch of salt. I'll try and make it useful so that you can go back thinking that yes, DK did speak some sense to us. What I'm going to do is actually touch upon the FC course first, and then I will speak about wills. I'm not going to take you through the handout which has been given to you, and I'm going to speak largely on the basis of what is relevant for you to know. And then I will be more interested in actually inviting you to a question and answer session, because I'm sure there are more questions than answers that I can provide. But having said that, let me talk about DIFC codes first. The subject has essentially, say, three elements to it. One is DIFC codes. What are they? Two, what does this jurisdiction represent? Three, do you have a choice? And should you make that choice? And if you make that choice, what are the consequences that flow from it? The UAE, I think, has a relatively, I wouldn't say immature, but a less developed judicial system. Initially, the judicial system was the Dubai Court, which follows the civil law principles, which started off in France. The French civil judicial system went to North Africa, and it was then borrowed from North Africa into the UAE. In 2004, when the Dubai International Financial Center was first mooted, there was an issue as to whether, for the purpose of certainty, a different legal system should be brought within the UAE. And it was decided that a common law system should be brought in the UAE, and that became part of the Dubai International Financial Center. And they are now called the DIFC courts. The DIFC courts are comprised of 3 English judges, 1 Australian judge, 1 Chief Justice from Singapore, and 3 local judges. So the idea in one sense is to bring about common law principles to be adjudicated upon, wherein even local judges are being trained in future. Why is this relevant? As you're all aware, and this is no discredit to the civil law system, but if you look at globally, if you look at financial transactions, they are irrespective of whether that financial transaction is a civil law country or a common law country, only common law principles apply to financial transactions across the world. So whether you're borrowing in Saudi Arabia, or you're borrowing in Indonesia, or you're borrowing in Hong Kong, or China, or India, common law principles will apply in terms of lenders' securities. And because they have now formed the template of all financial documents across the world. And that was one of the reasons that DIFC, when DIFC was mooted, they recognized that it is essential to provide continuity in relation to how financial transactions will work and what is the ability of risk professionals or lawyers to advise on the certainty of outcomes if there is an event of default in these financial documents. So I will not digress too far on that, but in any event, the DIFC courts were set up, and they were set up and became functional in 2006. We as KVH Kanun set up office in 2006 in the DIFC court, and the idea was to contribute to the growth of the courts. Now, so then the question is, what do these courts represent? They represent an alternative jurisdiction to the Dubai courts if there are disputes. Now, by and large, my experience is most international law firms are now providing for DIFC courts as a jurisdiction of choice in their contractual documentation. How did this come about? In 2009, we were involved in a litigation, which was the Karafis versus Saracen. I suspect some of you may have heard about the litigation where the Karafis, a Kuwaiti family, brought a claim against Bank Saracen and Saracen Alpen in relation to mis-selling of structured products. One of the issues that came about was whether Bank Saracen, which is a Swiss bank and which is not party to the transaction in the DIFC, could be litigated upon within the DIFC. And the courts gave a judgment that because of the jurisdictional law, which is, I will not bore you with the details, is Article 5 of Law 2004 as amended by 2008, any contract which is partially performed or entered into within the premises of the DIFC gives DIFC court jurisdiction. And on that basis, Bank Saracen employees who came to conduct meetings in the DIFC with the Qarafis allowed the courts to say we have jurisdiction over Bank Saracen because they were partially performing the underlying obligations in the DIFC. That judgment led to a change of the law. The law was changed to allow third parties, counterparties who were not connected with the DIFC at all, to opt in to adjudicate the disputes in the DIFC, and that's why you talk about choice. So when two counterparties, whether it is the bank or it is a non-bank, two counterparties, and if there is a financing component behind it, and where the bank needs to take security in relation to the counterparty obligations, one of the issues is, where do I litigate? So traditionally what had happened is that if there were two conflicting jurisdictions, you would opt for a third-party neutral jurisdiction and say, we will litigate in England or we will litigate in New York. That choice was not available prior to the change in the law. When the law changed and it allowed for opt-in, now parties, whether they are connected with the DIFC or not connected with the DIFC, they can provide for, in their contractual documentation, an ability to litigate in the DIFC. Now, it is a moot question for everybody whether that represents an advantage over litigating in the Dubai courts as compared to litigating in the DIFC courts. Whilst the Dubai courts will strongly and vehemently suggest that there is no advantage. But insofar as I said earlier, financial transactions have developed over the last 150 years on the basis of common law principles. Financial documentation, and I think there are several international conventions which impact upon the standardization of financial transactional documents, have all developed on the basis of common law principles. To that extent, any financial transaction, or I would say any contractual transaction, to the extent that it allows you to give a predictability of outcome in the event of a breach or an event of default, the DIFC courts will in the end advantage. But then you would say, then if I accept this as a paradigm, then all French courts would be discredited straight away. But that's not true. The reason why French courts cannot be compared with Dubai courts is French courts have a history of 200 years. The people who come into the judicial system, whilst they rely on a non-precedent-based civil law system, it is their education, it is their training which allows them to be better judges. The difficulty in the UAE, that the problem which Dubai courts have is the judicial officers of Dubai courts are yet not trained enough. Their history is very, very narrow. So we cannot compare French, which is a 200-year judicial system, or in English, to the Dubai, which is less than 20 years old. And it is on that basis, I would say, that if you are advised on from a risk perspective, this issue may not come before you, but if it did come before you, you should be able to say, to the extent that a system which provides predictability of the outcome, that should be preferred over a system which doesn't provide predictability of outcomes. So when you're doing, say, a credit risk analysis of a counterparty, one of the things to look at the documentation, what judicial system is he looking to litigate. So if I'm a borrower, for instance, and I insist on Sharjah law being the applicable law, I know that on a very technical ground, I can defeat your application. If you get the address line wrong, the application will be thrown away. If you get the name of the party wrong, application can be thrown away. So therefore there is a difference in how civil courts work and how civil courts in this jurisdiction work. On technicalities, you can suffer a procedural defeat. In common law courts, on the other hand, especially in lending and borrowing situations, substance will always matter over form. The courts will not look at technicalities. They will look at simple questions, and I've come this in situations where I have defended a $130 million claim, seeking to raise a jurisdiction argument, which I knew was manufactured. The court simply asked one question: did your client take the money? Yes. Does he want to repay it? What do you say? so that is the sort of question which civil courts will not address to you, but common law courts will do. So I've spoken about generally about DFC courts, opt-in, choice, how lawyers deal with these scenarios. The DFC courts is a very big issue to talk about, so I'll leave it there for the time being. If you have any questions, I'll be more than happy to speak more about it. So I think I'll move now to this more trendy topic, as Mr. X says, on wills and probate. Now, besides many other difficulties that people in the UAE face in relation to judicial issues, one of them was clearly the fact that how do you deal with assets of an individual who has expired? And I have been through that personal tragedy as my former partner in my firm, Kashif Basit, who was also the founder of the firm, expired 2.5 years ago. And I had to deal with the fact that he died without leaving proper instructions, without leaving a proper schedule of assets that he owned, and how to then deal with that issue. So, as a consequence, I took very practical measures in the sense that we segregated assets which are outside of the UAE and segregated matters which are within the UAE. I can admit within the confines of this room that I was economical with the truth to certain regulatory authorities on that. I didn't lie, but I was economical. By segregating the portfolios, we had to run one portfolio, the Sharia process, and the other portfolio through the probate process in the UK. What this told me was that once you are a non-Muslim, for instance, if you look at India, the rule of primogeniture and succession will follow to male heirs. To some extent, under Sharia principles, the same succession rule applies to male heirs, but male relatives, not male heirs, male relatives. The difference is that male relatives also have an interest in the succession. So, if I take the example of my one partner, although he was Muslim, and when he passed away, his family were absolutely clear that we do not want any relatives either from the mother's side or the father's side to have any stake in this issue. But under the Sharia principles, the brothers of the father and the children of the brothers of the father would have a stake in their estate. Now that in one sense represents a completely unjust scenario because they had no contribution to the family. So what it did for us was the problem how you deal with it. But let me talk about other more general situations which will come about. If you own an estate, or if you own shares, or if you own a business, or if you own a bank account, let's say I'll talk about 4 asset classes. A bank, which I would say liquid, shares, etc., which are also liquid, say real estate, which is non-liquid, or any other asset class, like a car, or say a boat if you own one, or something of that nature. Particularly, I think the biggest issue relates to an interest in a business. When, on the happening of that event, that is the passing away of the individual, if he has any interest in a business, then all activities of the business get frozen immediately. So the bank accounts will get frozen. The conduct of the business will get frozen till the issue is resolved by the Sharia courts as to who is the rightful owner of either the business or part of the business. And that's one of the issues we often advise on in relation to a 5149 structure. That is, if a 51 structure, if your sponsor passes away, it has a direct impact on your business. So one of the issues was about business. The second is about personal assets. Let's say if you're not a businessman, but you're generally an individual, you spend 35 years of your life in this jurisdiction, you've acquired a house, you've acquired cars, you have bank accounts, all of that. Now, again, two elements. One, do you have a will? Two, let's say there was no probate, wills and probate registry in operation prior to it. What was the effect prior to this actually came about? The effect was that if you had a will, it may or may not be recognized. There is uncertainty whether Sharia courts would recognize a will. It might be taken as, say, wishes of the testator, but there is no absolutely zero predictability as whether a given judge on a particular day will recognize your wishes or not. He may simply apply in his own thinking Sharia principles because that's what he's trained to do. You will make no distinction. So we have had discussions with several practitioners in this space, and there is no categorical answer as to how a Sharia court would treat the estate with a will or without a will. So either way there was an uncertainty. Now, what the will does for you is essentially outlines your wishes as to how you want your estate to be dealt with when you're passing away. What is the difference between just having a will and having a registered will? If you have a will, it is evidence that this is how you want things to happen. When you have a registered will, it is treated as proven. You don't need to prove that will any further in the court. And that is the real benefit of this registry. That is when you actually put your will together and you register it, you do not, the burden of proof as to that this was the intention of the person who passed away no longer needs to be proved. The dispute, if at all, will arise if somebody says, yes, this will was registered, but it does not reflect the true intention of the party who registered the will. In which case, as you might say, the burden of proof of evidence moves to the party who alleges the will is not correct. The will is taken to be correct by law because it is registered. So that is the significant advantage of having a registry. Now, you can compare that with, say, from a risk professional perspective, to the absence of a pledge registry. There is no pledge registry, so the pledges are uncertain. If there was a registry of pledges, the evidential requirement of proving the pledge goes away. Nobody needs to actually say this pledge is correct or incorrect because it is registered. Same effect applies on a will. Nobody can say whether it is valid or invalid will because it is registered. If I say it is invalid, I have to show circumstances and evidence as to why it was invalid. And if you will, if you're not familiar with it, but if you would have seen issues about this, circumstances would be, well, when the person who was making the will, he was incapacitated, he was of unsound mind, or he was under influence. These are the typical grounds taken where people seek to challenge a will, whether registered or unregistered. So what does this will do for, say, all of us, including myself, is to, if I have assets which I believe are at risk, then I register them, I put my wishes in accordance with the law, I provide a schedule of assets, and that gets registered. On the face of it, it is a fairly simple exercise. When the simplicity of the exercise gets tested when you actually go and seek a probate. Probate means that you are taking the will to the court and saying, I now seek to enforce this will against the assets in favor of the person who is the intended recipient of these assets. And the court will look at it and then obviously set out a period during which objections will be invited. If nobody objects, a probate will be granted, and then I will take the probate to the relevant jurisdiction, in which case being the Dubai courts. The Dubai courts will then issue an order that if it's a bank account, it now inures to the benefit of this individual. If it is a car, it inures to the benefit of this individual. If there are shares, they will be go to these individuals in this capacity and in this percentage and proportion. If there is lack of certainty in the will, and that's where the drafting the will becomes very important. If there is lack of certainty in the will, then essentially the problem will be that the courts will not be able to decide as to who should get the right proportion, who is entitled to what, and therefore effectively you will have to relitigate the whole issue by inviting every recipient in the will to make submissions. And I think it is human nature that when that situation arises, every heir will say, I deserve more. And that will cause the problem. So if you don't have a carefully drafted will, if you don't have carefully drafted schedule of assets, you're not certain about the outcome, invariably the will actually will become counterproductive. You would rather not have a will, because in that case you don't have to litigate. The court will decide. The court will decide equitably or inequitably, but at least you're not paying legal fees for that decision. So if you want to get it right, you must make sure that your will is in accordance with the law, and such that when it comes for a probate, there is a minimum dispute as to the outcome of what that decision shall be. The only other issue at this point which comes to my mind is the procedure itself. In procedure itself, I think it is still a very, very relatively new aspect which the wills registry is dealing with. We have commenced a few instructions in relation to the registration of will. I think the registry will take some time. As I say, my analogy about how the Dubai courts will acquire experience over the years in terms of dealing with civil law systems and then give sensible judgments, the same issue will apply to the DFC wills registry. There will be some teething troubles. They will deal with some registration issues. There will be test cases in relation to probate. Some may happen quickly, some may happen late. But it is not a reason for you not to undertake that exercise if it is relevant to you. I think, as I said, my own personal experience is that it is better done sooner rather than later. But that is, of course, a personal choice for all of us. On that basis, I think I will close my speech, and I'm very happy to answer any questions, whether incidental or substantive, or you might even consider silly. Don't worry about it. There is no question such as this.